Good morning, Ms. Andrews.
Good morning.
Please just forgive this rowdiness. I think we had too little sleep. We sat until late yesterday, so people will have a hangover. So forgive us.
You are forgiven, CJ.
Thank you. How are you?
I'm good. I'm good. I'm excited and suitably nervous for the occasion.
That's how we want you. All right. You've been here before, so you know the drill.
Yes, but if you would hold my hand through the process, CJ, I would kindly appreciate that.
I promise I will. All right. Although we have your transcript on record, for the benefit of those who don't know you, we'll go through your CV again. You were born in Cape Town.
Yes.
Born and bred there.
Yes.
And you did your studies and there and obtained your legal degrees there at the University of the Western Cape.
At the University of the Western Cape.
A BProc and you skipped the LLB and went straight to masters.
Yes, yes.
What was your master's on?
It was on international children's rights and family law, Chief Justice.
Your CV reminded me of it. It took me down my own memory lane. You were a shop assistant,
Yes.
factory worker, before you started on this legal path.
Yes, humble beginnings, CJ.
Sorry?
Humble beginnings.
Yeah, Bill's character. You were an attorney.
That's right.
For how long? For 14 years. Is it 8 or 14 years? No.
Chief Justice, I served 2 years articles from the 1st of April 1992 until the 31st of May 1994. Then I was admitted as an attorney on the 6th of May 1994. In total, I practiced as an admitted attorney for 8 years and 6 months. If you were to include my articles, it would be approximately 10 and a half years.
And then you were a magistrate for 14 years?
No, Chief Justice.
How long?
I joined the bench on the 1st of December 2002.
Already?
So it will be 21 years and 10 months, 22 years in December.
Yes. That's a long time. And
It
you
is indeed.
built your way from additional magistrate to regional court president.
Acting regional court president for a brief while before I accepted the invitation to act at the Western Cape High Court.
Yeah. So you senior magistrate, chief magistrate, regional magistrate, and where you are in KZN.
Yes.
But you've been acting at the Western Cape.
I have, Chief Justice, I've been acting for, 2 stints, one in 2017 to 2018, and then the second was from 2023 to 2024. In roughly, during the first stint, I acted for 39 weeks, Chief Justice, and then my current acting stint, as I now sit, will be approximately 76 weeks. I am going to be continuing for the first session, so in total I would have acted about 81 weeks in total.
All right, and during that time you've written a number of judgments.
Yes, Chief Justice.
And those that were taken on appeal were upheld.
Yes.
And you have a judgment that was upheld by the Constitutional Court.
That is correct. It's the Kapa decision on hearsay, Chief Justice.
Yeah, that's always a nice feeling. Huh?
It is. It was an unexpected one because I'd forgotten about that judgment, to be honest. And when when it came through, it was an affirmation, and it really was something that I felt I was able to contribute.
All right. You You are very active. I know you from the South African chapter of the International Association of Women Judges, but
Yes.
you've been involved in other bodies as well.
That's
JOASA, the South African Women Lawyers Organization, and the Association of Regional Magistrates of South Africa. Can you just explain something though? Your questionnaire says you remember of Nadel.
Chief Justice, I did send an answer based on the question that was raised by Nadal in this regard. And I'd just like to, if I may, just refer the Commission to my response in that regard. So, Chief Justice, so my connection with Nadal commenced before my interview in 2021, where I participated in the first dialogue session project to address gender transformation of the legal profession in August 2015. And then on the 17th of August 2019, I was invited to attend a workshop hosted by Nadal, which was held at the University of KwaZulu-Natal at the Senate Chambers. The theme of the conference was, in the era of #MeToo, women finding their voice. This workshop had a particular focus on sexual harassment in the workplace, within the legal profession, in school, and the effects of gender violence on the victim. After the conference, I participated in the conversation, more particularly as I was a presiding officer in the Sexual Offences Court at the time. I was able to provide input on areas of concern that had arisen during the discussion, and my input essentially centered around what I'd noticed as a presiding officer within the school space, such as the uncertainty that existed amongst educators on the correct protocols to follow when they are alerted to an abuse of a child. So my journey with Nadal KZN grew from there, Chief Justice. I had the wonderful privilege of attending other seminars and events. One such event was held on the 20th of August 2022 with the theme, Learning Through the Lens of Women in the 21st Century. Upon reflection, I made the decision that my commitment to the vision and work of Nadal had to be concretized. The leadership
had to be?
Concretized. So
concretized.
That is, yes. The leadership of Nadal KZN invited me to address Nadal and the UKZN student chapter at the inaugural meeting on the 3rd of September 2022. I was also approached to provide a message of encouragement to the students at the University of KwaZulu-Natal on the 16th of September 2023. And on the 2nd of October 2023, I started serving as an acting judge of the Western Cape High Court. And I have not been able to further my participation with the activities of Nadal since serving in the Western Cape from there. So I can confirm that as we speak, my membership has not been renewed. I have listened to the interview yesterday, and in light of the possibility of me ascending to the ranks of a judge, it wouldn't be advisable to be a paid member, but I can still be affiliated, is my understanding.
But you were a judicial officer already. That's my concern.
Yes, I wasn't sure at the time, Chief Justice, whether it was permissible. I had made some inquiries, and I did see some involvement by other members, and it was again perhaps something that I wasn't fully aware of at the time, and I'd realized that it wasn't the appropriate thing to do, because I was told that it was okay. but clearly it was not. I have then decided that the membership shouldn't be concretized in that way. And so going forward, I will take a step back, Chief Justice.
All right. Whilst we are dealing with Nadel, in their submission, their review of your candidature, they have raised something about which this commission asked you exhaustively last time, but they raised it again, so I suppose we might just as well get it out of the way. Just very briefly.
Thank you.
We'll deal with it briefly. They raised the fact that during an acting stint in 2018, you made a ruling which aided a senior Democratic Alliance politician who is her cousin, in their words.
Yes.
You've previously given an explanation for that.
I did.
Would you mind doing so again?
Not at all, Chief Justice. So what I did this time, for the benefit of the commissioners, was to attach my extempore judgment that will hopefully assist in trying to understand how I had approached the matter. So this was a semi-urgent matter that was assigned to me as an early allocation, which was set down for hearing on the 19th of June 2018. In brief, the applicants, who were councillors of the Beaufort West Municipal Council, sought an order declaring that the resolution taken on the 26th of February 2018 to remove them from office are null and void, together with an order restoring the status quo ante of the executive mayor, the deputy mayor, and the speaker of the Beaufort West municipality. The crisp issues which I was called upon to determine essentially centered around whether the meeting held on the 26th of February 2018, where the resolution was adopted, was legally convened and constituted in terms of the applicable legislative provision in the rules of order. The structure, Act 117 of 1998, and the Constitution of the Republic of South Africa. I prepared and dealt with the matter as I would all matters allocated to me.
Ms. Andrews,
Yes.
you don't need to go through all that.
Oh,
All I
okay.
want to know is whether you were aware that your cousin was involved in the matter. When
No,
you
I was not,
adjudicated it.
Chief Justice. Again, I've indicated, as I did on the last occasion, the first time that I was alerted to this was when a news article about a week later was published, and this was then raised therein. This obviously got me very anxious about what had happened. I had no idea at the time that this matter had any type of impact on him as being my cousin. I do want to say, though, that in terms of my background with my cousin, my family history, and I would like to become a bit vulnerable, if I may, to the commissioners, it stems back from my childhood, where my mom and dad were divorced when I was 6 years old. I was raised by my mother, and so that my cousin is a cousin on my dad's side. He's 17 years younger than I am, so we never really grew up together. His political career, as I understand it, became known and in the spotlight about 3 years prior to me writing this judgment. In terms of me having any type of a connection to him on any other level apart from seeing him on occasion in the news highlights, there is no other connection. Having said that, so nothing alerted me from the papers that he was in some way, manner or form connected. However, on reflection and in hindsight, I ought to have applied more introspection. It should have sparked a light bulb, and I admit to that. And I take to heart the critique that was raised, and it was a learning curve for me. I can give the Commission every assurance that I take my oath of office seriously. My lens has been sharpened, and I've grown in judicial maturity. And if anything, this learning experience has made me a better judicial officer. If you would look at the judgment that I delivered, Commissioners, you will see that my lens was on the Constitution and the rule of law. I was of the firm belief that the rule of law was breached. The decision was predicated on the principles of legality to some extent. And so, again, if one looks at what had happened and the building blocks upon which the rule of law is predicated, a transparent government is what the Constitution demands. And it is for those reasons that I obviously made the ruling. That is the lens through which I viewed it, and there was no influence at all in my decision that it would have, the outcome would have assisted my cousin in any way. I have apologized to the previous judge president for my oversight and for my lack of judgment. I have erred, and I will do better. Thank you, Chief Justice.
Thank you. Back to your illustrious CV. You have undergone training in arbitration, so you have a course well, you've completed arbitration skills training and equality training, and you are a designated presiding officer of the Children's Court.
Yes, Chief Justice.
And you also sit in the advisory board of the Small Claims Court.
I did when I was,
in
Mitchell's Plain at the time. I was the senior magistrate, and that was part of my duties. The Small Claims Court was established during my tenure as a senior magistrate, and it gave me an enormous pleasure, and it was an enormous privilege for me to be part of that, because, as you know, being in the heart of Mitchell's Plain, it was bringing access to justice to the people of Mitchell's Plain. As you know, Small Claims Court plays a very pivotal role in order for justice to be meted out to the very vulnerable and those that cannot access our courts. So yes, it was essentially encouraging justice between man and man, and it was a wonderful privilege to be a part of that, Chief Justice.
You've listed a few health issues you say you have, but you reassure us that everything is under control.
I am as fit as a fiddle.
Okay.
I've just done that for full disclosure, and on the last aspect, I can confirm that I have got a clean bill of health since my last blood test.
Okay. Do you have any reserved judgments, long outstanding part-head matters?
No reserved judgments. As I sit here today, Chief Justice, all the parted matters that I've listed on my application have been concluded, bar one. That matter is on the roll for, and on the tail end of it, on the roll on the 17th, 2 days from now. The reason for the further adjournment in that matter was because I felt it prudent for the matter, for input to be made from the central authority, which has now come to light, and so that should also be finalized in due course.
Thank you, Ms. Andrews. AJP Goliath.
Thank you, Chief Justice. You have served the division intermittently, it appears to be in 2 stints from 2017 onwards, and then again 2023 and 2024. How did you find your progression and your growth as an acting judge having started in 2027 and where you are now?
Thank you for the question, AJP. As I sit here today, I can give the commissioners the assurance that the growth spurt, and I'll call it a spurt, has in my view been phenomenal. As you mature in judicial maturity, your approach and my approach has been so different. I have embraced the new opportunity with every fiber of my being. Commissioners, I have invested lots of time. I am very, very committed. And no matter assigned to me was too much. I have at all times enjoyed the new challenges because it is, in my view, sometimes like lucky dipping. So when you get a new file, I'm excited to see what's under the brown cover, and hopefully we'll go beyond the brown cover into digitization, AJP, but yes, I'm excited about that. And so I can say with a fair amount of certainty that my approach to my work is a lot more focused in the sense that I want to make a difference. I want to make a mark, and I want to be that ripple in the pond. I want to be the best I can and give the best, because for me it's about serving, and that I do.
The Western Cape High Court is a very busy division. How did you find the workload? Because we know that the tap never closes when you are an acting judge in the Western Cape High Court. Did you cope with your workload?
I coped very well. As I sit here, I have no reserved judgments. I think my skill set in judicial management has assisted me to be able to manage the workload. It is about knowing how to and I call it triaging the matters, how to prepare. And also having been on the aspirant judges course has equipped me also and readied me and steadied me for this journey ahead. So a lot of the groundwork is done before you walk into the courtroom. It's about reading those files and in some instances beginning to write the judgment before you even start the matter. So you have a fair understanding of what's going on, and that assists you to get through the final stages of the judgment. Some judgments are more complex than others, and it takes a little bit more time and a bit more research is required, but that is what one has to do. You have to put in the hours. I'm at work between 6:30 and 7 in the morning. I'm working over weekends, public holidays. I have invested into this journey, and for me it is about getting the best outcomes for every litigant, because they deserve a good outcome.
In terms of the type of work that you were allocated, did it cover a broad area of the law? Or are there any areas where you feel you may be lacking in terms of exposure?
AJP, I think I have been exposed to various areas of the law. I was exposed to criminal work and to civil. I was in the civil pool. I did motion court, opposed, unopposed, civil trials, rule for various interlocutory applications, and the like. I think there's one particular area that I wasn't exposed to, and that is tax. But apart from that, I don't think there's any matter that, even if it's new, I would still be able to navigate my way around it. I've never shied away from work, and I've never returned a file to say it's too much for me. And as you know, AJP, some of those matters are quite voluminous, lots of lever arch files in some instances, but we get through it, and it's about preparation.
What was your relationship with the colleagues on the bench? How was your relationship with the colleagues on the bench? Did you have any problems?
I had no.
And if I can just add to that, how did you find the support system in the division from permanent judges?
Thank you, AJP. For me, I am collegial, and I am a firm believer in maintaining good relations. I am respectful, and I understand the protocols. So when I work with any senior judge, I defer to seniority. I have had good relations with every single judge that in the division that I have had the occasion to work with, and even those that I haven't had an occasion to work with. The senior judges have an open door policy. You can go to them if you need to maybe bounce something off of them or just get some guidance. I've done that a number of occasions where I am not certain whether I'm on the right track, and those measures have all been have all assisted and fortified me with the reassurance that there is collegiality, there is some type of fortification, and amongst the acting judges, we've also have a support network that we've developed so that we can try and pull each other through the very difficult days. And sometimes there are days where you just feel overwhelmed, but we get through it.
As mentioned earlier by the Chief Justice, you have written some complex judgments. It appears as if you have certain strengths in the area of family law.
Yes. When, as a practitioner that started out in the 1990s, I think most of what we were exposed to those years back was premised on family law and criminal work because that was our bread and butter. And then, of course, I expanded in my thesis on international family law and children's rights for that very reason, because I have a passion for children, I have a passion for the vulnerable, I have a passion for women, and for all of the people who have really been affected in ways that I can say family-related issues, that is real. It is things, it's about things that happen on a daily basis in the community that we need to be alive to. Having said that, as judges, I believe that we need to be grounded and we need to understand the plight and the heart of our community. And so, even as a magistrate, the family courts were part of what I did, and seeing the need and the hurt and the pain of our community really made me feel that that was where I needed to invest.
So the judges in the division, there is a need to appoint some judges and designate them as Hague Convention judges. Should you be appointed, would you be able to contribute in that regard?
I certainly will, AJP. The strength, I would say, that I would bring to the bench would be in that area, because that is what my studies were centered around, and my mini thesis focused on links between international child abduction and relocation disputes. Other areas of my coursework provided me with the understanding of international surrogacy laws, international inter-country adoption, international children's rights, conflicts between rights of the child and other rights enshrined in the Bill of Rights, child-aided households, and the base of my studies was predicated on the Hague Convention and the Africa Charter on the Rights and Welfare of the Child. So absolutely, yes, AJ.
You were involved in SAJE training. In which areas did you assist SAJE in the training of magistrates?
I was involved on an ad hoc basis, but as regional court president, that is when I needed to really step up to the task. The aspirant regional court magistrates needed training, and so my input centered around the civil component, family law, family advocates input. So where my strengths were, as well as obviously hearsay, in light of the judgment that I'd written in that regard. Then I also, as acting regional court president, introduced a course to aspirant regional court magistrates who are aspiring to be appointed. And it was the first of its kind that I collaborated with SAJE on. And so we vetted a pool of eligible practitioners from all areas of the legal profession. And I then sourced other peers and magistrates and judges of the KwaZulu-Natal High Court to assist with that training.
And then lastly, can I just get clarification? I made a note here that you said that none of your judgments have been overturned to date. Is that the
That
position?
is correct,
Thank you, Chief Justice.
to my knowledge.
Thank you, Chief Justice.
Thank you, HAP. Mr. Boshoff?
Thank you, CJ. Morning, Mr. Andrews.
Good morning.
Given the location of the division and the fact that Parliament is in the province, obviously the provincial government, the metro and various municipalities, administrative law makes up quite a large part of the caseload in this division. So I'm just going to ask two kind of technical questions on the subject matter, and then please, it's not to catch you out or anything. I'm going to be asking it of all the candidates.
Very well.
So there's the so-called, I suppose, colloquially termed Part A and B applications, where Part A is for interim relief pending the final application in Part B. What is your understanding of the reliance on a general right to review or a general right to fair administrative action as the basis for establishing the prima facie right component of interim interdicts?
Well, as a starting point, the exercise of all public power is subject to judicial review, and judicial review is a mechanism for keeping public authorities accountable to uphold the rule of law. So when we are dealing with the principles of legality, it is derived from Section 1C of the Constitution, which is the incident of the rule of law, which is the principle of legality, which holds account the exercise of all public power and for the performance of a public function, reasoning, and it aligns with the transformative constitutional agenda, which speaks to the principles of accountability, transparency, responsiveness, and openness. The exercise of all public power needs to be justified in order for it to be lawful and valid. And so in terms of, and I'm predicating my answer just so that I can give you the assurance that I do understand the nuances between the principle of legality and when paja is invoked, and that when we look at it, we look at it through the lens of the cases such as Fetch or Safu, as well as the pharmaceutical matter, where they interpreted legality to be an act reasonable and to give effect to reasonableness. In Safu, it was the good faith consideration, and in pharmaceuticals.
Sorry, Chief Justice, I really
Yeah.
apologize that I have to intervene,
Yeah.
but this is gonna really be long.
Sorry.
But so I would really like to just refocus the question. It's two components. An applicant brings an interim interdict.
Yes.
What they say in the interim interdict is that for the prima facie part, we are relying on the general right to fair administrative action, which is in section 33. Now, can they do that to secure an interim interdict, or do they need to show something more?
Thank you, Commissioner. And if I can perhaps be of
Yes.
further assistance, are you familiar with the case of National Treasury versus Outa, in which the Concord dealt with this very question?
Yes, as far as I am, are you talking about an interim interdict?
Yeah, so we're going to court. Let's
Yes.
say we've lost out on a tender.
Yes,
We go to court, we want to stop the implementation of the tender, and our reliance for ticking the first box of the interim interdict is to say, we have a right to fair supply chain systems or procurement in terms of section 217 of the Constitution, and that is the prima facie right we're relying on to satisfy that part of the interim interdict requirements.
yes.
And courts have engaged with this quite a few times, and in the last month, there have been 3 judgments on this very issue, where the courts have engaged with this on the basis of the outer judgment. And I just wanted to test your understanding of that. And please, if you're not familiar with it, it's fine, we can
Yes.
move on, really. It's
No, I'm not 100% familiar, but I would be able to navigate that. I haven't been given many matters dealing with administrative action where these complex issues have been raised, but I have a good understanding of what the requirements are for an interim interdict and for final relief. And so I would build around that, and I would certainly know how to research. I would back it up, and I think from the manner in which you see me approaching a judgment, I would look at it from an academic lens. I'll look at it from the reported case law, and then I will be able to give you an outcome based on that. Thank you.
Thank you. And then the next one, just what is your understanding of the concept of collateral or reactive challenges, and can organs of state raise them?
I'm not certain.
Okay, thank you.
Thank you.
Nothing more, CJ.
Commissioners? Commissioners on the virtual platform, do you have questions for the candidate? Professor Marumakhai?
Thank you very much, CJ. Good morning.
Good morning.
Can I please take you to your documents of evidence?
Yes.
In page 58, and I think it's paginated page 57.
Yes.
Yes. There is a judgment there, which is a reported judgment of Boysen versus Stander.
Yes.
In that judgment, you had 2 people. One was relying on, they wanted to share a property and some of the assets
Yes.
in their partnership.
That's right.
And one was relying on a common law remedy of actio communi dividundo, and the other one was relying on universal partnership. When I read this judgment, first and foremost, you start by detailing what each party's case is. And only at paragraph 42, you tell us what the main issue that needs to be decided on the case is. Now, that is not what I want to ask you about. That is obviously a challenge, but that's not the point.
Yes.
Then you state what you believe the relevant law is. After doing that, then you go to what you term the discussion. But in the discussion, it doesn't seem like you are actually dealing with the common law remedy and the universal partnership. And after 4 or 5 short paragraphs, you come to a conclusion. So now, what I'm confused about in this judgment is what led to you adopting the fact that the plaintiff was right on the common law remedy and that the defendant was wrong on the universal partnership. That doesn't come out clearly. I just want to understand your reasoning
Yes.
in the judgment.
Thank you, Commissioner. The judgment was written when I was still quite new on the bench. And obviously, I wasn't comfortable in writing judgments of this complexity. I acknowledge that there is room for improvement, and I believe that with time I am able to grow. The common law remedy or consideration was based on the evidence that was provided by the litigant. This I weighed up in terms of all the other probabilities, and it doesn't come through very clearly in my judgment. But I can give you the assurance, Commissioner, that I do understand what the considerations are in terms of the manner in which an action proceeding is to be dealt with. And then, of course, with my insight into how to approach matters in general and how we are meant to develop the common law through the constitutional lens, certainly going forward, I will take to heart the critique and apply it.
Okay, no, that's fine. My second question is, assuming that on this particular judgment, the plaintiff is not happy with the order, and they want to appeal the order, what is the test for the application for leave to appeal? In other words, what would satisfy, what they ought to do to satisfy you to grant them leave to appeal?
Yes, that would be born out of Section 17 of the Superior Courts Act, which sets out what the criteria is, and in the main, it will basically be predicated on whether or not another court would come to a different conclusion.
Is that the test?
The test.
Yes. I'm just saying, is that the test that they need to satisfy? Okay, no, that's
Okay.
fine. Let's leave it there.
Okay.
Thank you very much, CJ.
CJ, may I just follow up on the question relating to the judgment that the professor asked about? Good morning,
Good morning.
ma'am. Following up on the question that the professor asked you about this judgment,
Yes.
JS versus JHS. Well, first, let me commend you that it is a good judgment, and it deals with the practical and the lived experience of women who more often than not find themselves in unequal power relations in their affairs. But then, as I read the judgment, I was also as confused as the professor was in your attempt to distinguish between actio dividendu and the universal partnership. But then there is an importation of just an equitable remedy that you brought into the judgment, which is ordinarily not a consideration when you deal with universal partnership. And I thought I should ask you, what actually motivated you to break away from the principles as outlined in universal partnership, the requirements of a universal partnership? So why didn't you just stick to dealing with the case as a partnership between life partners and not bring in the just and equitable remedy?
Obviously, with the benefit, thank you, Commissioner, for the question. Obviously, with the benefit of hindsight, looking at it through a different lens, I think one could look at it or have those concerns. For me, it was more about taking a step back and doing what was needed for the litigants, being steeped in the atmosphere of the trial. It was clear that they both needed to share equitably. And maybe my reasoning wasn't clear in the judgment, but my thought process was that they needed to have there had to be some equitable division so that each of them would be able to share in the estate that was built up over quite a number of years in the union.
Thank you, Chief Justice.
Commissioner Ngqodo?
Yes, thank you, Chief Justice. The problem, Ms. Andrews, that I'm grappling with right now is I just don't know how to assess your candidature and your knowledge of the principles of administrative law. Because on the two administrative law questions that were asked by Commissioner Boshoff, you didn't do well. So I just want to re-ask those questions in a practical way, not in an exam type way, and just test what your grasp of these principles is, especially because you're trying to become a judge in Cape Town, which is basically the seat of Parliament, where probably 60% of civil cases are public law cases. So let's start with the first one, which is the outer one. Let us assume that you are preparing to come to your interview here at the JSC, and a political party brings an interdict to stop the JSC from interviewing you. And we know that the process of interviews is provided for in section 178 of the Constitution, in terms of the 174 of the Constitution, 165 of the Constitution. So when the JSC is interviewing you, it's exercising an original constitutional power. And somebody says, I want an interdict against the JSC from interviewing Ms. Andrews. What do they have to show on the outer principles in order to succeed? And the case came before you. What would you require the applicants to show in order to succeed?
The applicants will have to show a clear or prima facie right, that they would have to show that there is irreparable, potential irreparable harm, as well as the balance of convenience that needs to be in their favor, and that there is no alternative remedy.
And I'm saying in outer.
In outer.
Yes, what would they have to show? That's Webster versus Mitchell. But we're talking about an interdict against the exercise of a constitutional power.
I'm sorry, I've just drawn a blank.
All right. Now then we look at the second issue, and it was phrased in technical terms as collateral or reactive or defensive. But let us assume that an organ of state has given a tender to party X, but it no longer wants to carry out with the tender. And then party X comes to court and they say, I want to enforce my tender. And the government now says, no, no, no. The way in which we gave you this tender was unlawful. That is their defense. How can they raise that defense between PAJA and legality?
In terms of PAJA, that would be based on the administrative action, which then would invoke the provisions of PAJA, and then you would have to look at the grounds set out in Section 6 of PAJA to see whether that is, it fits that requirements.
And then if it's an organ of state and then they say, no, we want to set aside our own decision, can they rely on PAJA?
The administrative action, in my view, is there just for the administrative the administrative action has to be defined within PAJA.
Yes, now I understand.
Yeah.
Let's not go to the definition.
Yes,
It
and
will
it
take us a
applies
long time.
whenever.
I just
yeah.
want to know, if I'm an organ of state, I've given
Yes.
a tender, I don't like it, can I rely on PAJA to set it aside?
An organ of state will have to rely on the principle of legality.
Yes, and then PAJA will be applicable or not applicable.
That is where there's a gray area, because in some instances, if PAJA covers it, if you look at Beta Star is the authority that says that if it fits within the PAJA definition, then that is how it should be adjudicated.
So as far as you understand, an organ of state has a choice between PAJA and legality
An
to
an organ of state would then be on the principle of legality. PAJA is for an administrative action.
Now, I understand. Well, I'm saying, can an organ of state say, I want to go to court to challenge my own decision to award a tender or not?
It has happened.
I know, but
yeah.
I'm asking what the law is, because now you are the judge and I'm coming to you, I'm saying I'm acting for Transnet. We've just given this tender, we don't like it, we want to say this, and I've got an application, and you look at the notes of motion, it says in terms of PAJA.
Commissioner, I'm not 100% sure.
All right. No, that's fine.
But I would, obviously, when a matter like that serves before me, I would double check to see whether or not it falls within the PAJA Act, or whether or not they have missed the application requirements, and maybe it should have been brought with under the principle of legality. And because if one looks at it, it is the rule of law is what the principle of legality is based on.
All right. No, thank you very much. Thank you, Chief Justice.
Thank you.
Judge President Mlambo.
Thank you very much, Chief Justice. Good morning, Ms. Andrews.
Good morning, JP.
I just need clarification. In your extensive acting stints, you mentioned 81 weeks. These are all in the Cape Division?
Yes.
In what areas have you acted predominantly? Is it criminal or civil?
In both areas, but predominantly in the civil pool,
Predominantly it's?
in the civil component.
Uh-huh. Okay. Thank you very much, TJ.
Thank you.
Thank you, JP. Ms. Andrews, we've reached the end of your interview. Anything you want to ask us?
No,
Solicitors?
Chief Justice, I'm covered, and I'd like to thank you for the opportunity to present, and I'd like to thank the commissioners for the opportunity as well.
Thank you for
Thank you.
making yourself available. You're excused.